Hello, good night. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments now. Tonight, I'm going to answer a very important question, and it is going to be, can you be deported while your case is pending? Because that's what they have just announced changes in the USCIS policy manual regarding family and marriage based green card petitions. And one of the items in the policy manual now states that if they do find that an immigrant is deportable, that they may issue a notice to appear in order to defend against deportation, even before a decision is made on the petition. What does that mean? Does that mean that as soon as you apply for this petition, you could find yourself in deportation? In some cases, yes, your risk will go up, but I want to be able to explain to you what this means exactly so you understand to a certain extent that it's important for you to get legal guidance about what your risk is. Now, here's the number one thing I'm going to say. You qualify for an immigration benefit, you should apply for it. But in this case, you need to make sure you are applying carefully, right? So if there's saying applying for a petition alone and saying, say you're here, you've overstayed your visa, because that's the number one concern. You're applying for a family-based petition, you've overstayed your visa, and maybe you even came into the country without permission. Does that mean you're gonna now get a notice to appear in immigration court? No, not necessarily. Here's the deal. The changes to the policy manual are in reference to the petition. All right. A petition, a standalone petition, we've always known a standalone petition does not give you any kind of immigration benefits. So if you file a petition by itself, and they don't see any kind of other documentation there that would grant you the ability to get protection or to have temporary protection, then your risk goes up. So you want to make sure that if you're here in the United States, you've overstayed your visa or you've entered the country without permission, that you do have what's called an adjustment of status application to go along with the petition. Now, let me explain something very important to you. Has the law changed? Because if you've been following me, you know that if you are married to a US citizen, right? You're here, you're married to a US citizen, maybe you've overstayed your visa, you know, based on what I've told you, and that still exists, is that spouses of US citizens, children of US citizens, parents of US citizens who are here, who are applying for a process through adjustment of status, will be able to move forward despite the overstay. Because based on the law, this is not anything discretionary. This is not the government that's making that decision. Based on written law, they will, and this is the INA, the Immigration and Nationality Act. The INA, the USCIS officer cannot deny you the immigration benefit just because you overstayed and send you to deportation. However, when you're applying for adjustment of status, that is what is signaling to the USCIS that you are staying here in the US and you're applying for the green card while you are here in the US. Because of that, adjustment of status gives you temporary protection while you're applying, and you're able to get your work permit and your social security number while that's pending, right? So If though you filed a petition, you qualified for adjustment of status, you filed a petition though without that adjustment of status, then there is nothing in place that's saying you would like to stay here, get temporary permission to be here while your process is moving forward. And that, my friends, is where an immigration officer can have the opportunity to issue a notice to appear, because now if you didn't apply for adjustment of status to signal that you would like temporary permission to be here while they're deciding your case, then they're going to look at it and say, oh, you have an overstay, you never filed for adjustment of status, that of course you qualify for. So we are going to issue that notice to appear. Yes, you may qualify for the petition, but guess what? You can deal with that from outside of the US. If you get deported, you can deal with that from outside of the US. But the adjustment of status application is what enables you to be here and to apply despite the overstay. So it really comes down to strategizing based on the current law and based on procedure, because the changes that were made was not made to the adjustment of status application, it was made to the petition. So this is where I say there's no room for errors here. There's no room for errors. Get in touch with an attorney, get in touch with us. That is exactly what we do. We help our clients to do this properly, to reduce the risk of being issued a notice to appear. So very important that you understand that distinction. It does not mean just filing a family-based petition, just filing a marriage-based petition alone is not going to get you in deportation. But the way you do it and procedurally, you follow all the rules procedurally, that is where it's going to matter the most. I do want to make one notation though. No, filing a petition, if you are here in the United States and you are say, I'm going to give you an example. You are the son or daughter of a US citizen age 21 or older. At the same time, you've overstayed your visa or maybe even came into the country without permission. Now, you are thinking about filing for the petition, for your parent to file a petition for you, but you don't qualify for adjustment of status. That's because you're in a different category than the spouse, the parent, or the child under 21 of a US citizen. Since you're in a different category, they will hold an overstay against you, and an overstay does disqualify you from adjustment of status. So in a case, unless you're applying for VAWA, and even then, you still have to have a current priority date in order to move forward. But here's the deal here. You file that petition, but you don't qualify for adjustment of status. That's where you may get a notice to appear, because the officer can look at that petition and it's approvable, everything, you qualify to have it approved, but that officer is like, there's nothing though to justify you being here for the rest of the green card process. So what the officer could do is say you overstayed, or you have some other immigration violation. There's no adjustment of status process in place that says that you should be here for the rest of the process. So they may issue a notice to appear in that case. Right. And that gets really sticky when you're going to look at applying for an I-601A waiver, because you have to apply for an I-130 petition before you can get to a waiver. So that's where it gets sticky. Now, I know I'm giving you a lot of information and I'm trying to break it down as simply as possible. But this, guys, is where you need to make sure that you get help. right? Get legal assistance going through the process to reduce any risk of any unexpected surprises, any referrals for removal. Make sure that you get the help, because no, it's a little more cumbersome and there's a little more, it's not as straightforward as, even if you file an I-130 petition, you'll be fine. You know, it may take long, but you'll be fine. They're not going to hold it against you. No, filing an I-130 petition can put you on the radar and then trigger notice to appear in a situation where you don't qualify for adjustment of status. So give us a call. This is exactly what we do. So now is the time to give us a call. Let's make sure you qualify for adjustment of status and move forward. Let's take action very quickly. But it's so important to have a safe space where you can sift through these, and where an attorney like ourselves can sift through what your risks are, whether you qualify for the benefit, and then move forward to guide you through and represent you through the process. All right. So that is just a little more analysis about this, because I'm seeing headlines everywhere saying even family members and spouses of US citizens can now be deported during their process. And I just wanted to try to break this down for you in a way that you understand it should not stop you from applying for something you qualify for. But to make sure that you understand what to expect, this is get representation. It's as simple as that. Get representation, because the stakes are a lot higher. Here's the other thing I wanted to point out is they have also said that they are no longer going to give the applicants a heads up that they need a document, and if they don't get the document, they'll deny the case. So usually what they will do procedurally is they will issue, if they say something is missing in the application, say maybe a translation, a certified translation document, or a document proving the relationship between the petitioner and the beneficiary, the immigrant, right? So, for example, showing the parent-child relationship, or showing the spousal relationship. Say that document is missing. And maybe it's an oversight on your part. Maybe you forgot to stick it into the packet and it's just not there. The officer now has the discretion to say, oh, that's missing, denied, right? Rather than saying, here's a request for evidence, send a request for evidence to you and say, hi, we just noticed this document is missing, provide it, and we will move forward with your case. But if you don't, we could deny the case, right? Not to say requests for evidence are going away completely, but no, the USCIS has stated that an officer can just send a denial without a request for evidence. Now, I practiced during Trump 1.0, and that was the case as well. And I believe that is why we are so detail oriented, because I did practice during the last administration. A huge part of my practice was during the Trump administration. And I always had to make sure that the applications were pristine, they were thorough, and they included all the requirements because of this rule. And now it has come back where they're saying they can deny without giving chances. So once again, the stakes are high. There's really no room for errors. There's no room for like, I'll rush this off, send it off quickly, as a lot of notarios do. A lot of these so-called immigration specialists, they will rush your application along, take your money, and then disappear on you, right? And then maybe there are some things missing in the application, or sometimes they will say this, let's just file this. And then when we file it, you can always, or we can always send some things later on. that is not a risk that you should be taking. And so this is where it's very, very important to know the stakes are a lot higher, guys. So do it right the first time. Do it right the first time. See, someone says, happened to me. I'm so sorry. And yes, it turns into a nightmare. It can be a nightmare. And usually when you're calling that person to say, hey, sometimes even just calling to say, I need a copy of whatever you filed, they're not available. All of a sudden, that's not my problem. I just filed this thing for you. And you are in a lot of hot water at that point. So it's getting a lot more stressful. But this is where I say, don't panic. We are not here. We are not basing our approach on panic. What we are doing is we're solution oriented, and we are focusing on how can we get this done, not don't do this. If you qualify for something, empower yourself, still go for it, but do it smartly. And that's what we're doing here at the firm. All right. So now that I have covered that topic for tonight and say, you told me she was a lawyer. Oh my gosh, be careful, guys. Only thing I'm holding on to is my notified marriage. So I'm so sorry that happened. Yes, and some people will pose as lawyers. And keep in mind that there are people that even pose as me. So there are fake social media accounts. So call our official number. If you follow my page here, I do have a backup page on TikTok that's not very active right now, but I have my official pages on Instagram, on Facebook, on in YouTube, and on TikTok. So make sure you're following those official pages and talk to our staff. Call our official number, and you'll be able to talk to our staff there. We do not give, just tell you a price over the phone, like say it's $3,000, send us the money. Um, we don't do that, guys. We go ahead and we first make sure that your situation is one we can help with, and then we move forward from there with a consultation fee of $150 first. We don't do Zelle. We don't do the only one we do is PayPal. We don't do Zelle. We don't do any kind of exchange of information through WhatsApp. We don't do Venmo, Cash App, or any of those. So give us a call, talk to us. We go through an initial intake process, and then we schedule that appointment. So go ahead, guys. We're a safe space. Do that. And yes, be wary of the scammers. No, it's not the time for mistakes, because mistakes now can have very, very severe consequences. And ironically, yes, we do removal cases. We do need sufficient time to prepare your case. So you can always give us a call and we can talk through your case and get started on removal defense. Well, absolutely, we are involved in removal defense as well. All right. So I'm going to answer some questions tonight. I'm going to start. I know I see a ton of questions on TikTok, so I'm going to start on TikTok to get through the questions and move my way across. So hang tight, guys. I'm going to read the questions and then answer them so we all can take away from what those questions are. We can all learn. You take calls on Sundays. Yes, we take calls 24 hours a day. So go ahead and make sure that you're giving us a call. If you're thinking about your immigration situation 3 in the morning, you can bet on it that you can contact us. We'll answer the phone or we'll call you with your permission of course, at 2 in the morning. Um, how long does BFD take for a U visa? So my experience about a year and a half to 2 years. You take calls on Sundays, yes. So this one is in Spanish, but it says here, so forgot to, is it fraud to forget to mention divorce in the I-485? Um, they think the divorce and so it's very important if you see that you forgot to give a detail, make sure while always before you're giving them information, disclosing anything, it's always best policy to be honest. But if you're concerned about something like that, it's time to talk to your attorney to know the best way to approach this. If you've missed anything, because they can potentially determine that there is some fraud just depending on the importance of the information. So after August 20th, everybody gonna get a visa if they pay $15,000? No, that's not what it means. What this new bond that they have in place, so they just put it in place for Zambia and Malawi, but they're going to continue to add countries as they go through this pilot program. Unfortunately, what it means is that it's in order to get the visa or in order to enter the United States, you have to pay a bond of, and they set the bond, it's 5,000, 10,000, 15,000. And I believe Malawi and Zambia are set at 15,000. So what that means is if the person can't pay a bond, then they cannot visit the United States or enter the United States with the visa. So it's a very, very high price to pay, and not a lot of people are gonna have that money to pay. So it's going to decrease immigration substantially in those countries that have that bond requirement. So that's what it means. It doesn't mean everybody pays 15,000, but they are gonna impose those bonds on citizens of certain countries. With new policy, is it true that if you're out of status and apply for adjustment of status, you're in removal? No. So this is what I just explained. Adjustment of status is the process that allows you to stay here and go through the process. But the change that they have described is in regards to the family petition. So the petition alone, if you file a petition alone without an adjustment of status application, then that means that they can look at it and say, you're here in the US, you overstayed, and we don't see any adjustment of status where, you're getting permission to be here while you wait. Okay, we can issue a notice to appear, but even before a decision is made, and then even if we approve it, you can deal with that from outside of the country. Of course, it would be a pain to do it from outside of the country, but that is the distinction here, right? Now, with adjustment of status, of course, if they do see as always, this has always been the case with adjustment of status, if you don't qualify for adjustment of status, because of, say, maybe you mistakenly applied and you didn't qualify for adjustmental status, they can then go ahead and put you in removal because you didn't qualify for adjustmental status in the first place. So this is where it's very important, guys, to understand on a case-by-case basis, what's the risk level? When you apply for adjustmental status, what will happen in your case? Because in your case, you're filing for adjustmental status, you're the spouse of a US citizen, you overstayed your visa, you're totally allowed to do that under the law. They are not supposed to hold the overstay against you unless they deny the adjustmental status, which they're not going to deny an adjustmental status just for an overstay. Right. So that is the distinction. I know it's if and of course that's why I am the lawyer, and that's why we're lawyers here, is because we have to look at these and be able to tell the difference here. All right. What about those people like F1 and or F2 categories? Are they at risk for NTA? No. I mean, unless there's a violation of the immigration law and your student status is revoked, getting an NTA while being on legal status is not a thing, right? So you would not get that just by because you have legal status. So and that's the thing with the adjustment of status. The whole point of the adjustment of status application that you're filing along with the petition is to say, can I stay here while I am allowed to stay here while I wait for the process to be completed? That's what the adjustment of status application allows you to do. So here's what I say: do not file a petition unless you fully understand the risk. So this is where you hire an attorney or you talk to us. Let us work through that with you. And also make sure that you qualify for the adjustment of status, right? But under the law, if you overstay and you are the spouse of a US citizen, you're the parent of a US citizen, you're the child under 21 of a US citizen, or you are applying for VAWA, you are allowed to be here. It is a part of the law that allows you to be here while your process is going forward. So I hope that helps. But don't let, if you qualify, do not let this stop you because it's a part of, I would even say it's a part of the psychological warfare, right? By putting this out in the policy manual without being very specific about what this means, it has now even signaled to people who do qualify that they will go to removal. So what does it do? It works to stop people from applying for benefits that they qualify for. So it's very important to know that you need to empower yourself to go through the legal immigration process. Do not sit in the shadows because of this very vague statement in the USCIS policy manual. It is vague, and I've just worked out what it means. So I know it's complicated, but that's why I'm here. That's why we're here as attorneys. We're here to simplify it and guide you through the process. All right. Does the bond apply to the fiance visa? No. This is visitors visa, certain business visas. What about T visa? Are they qualified to be here? Yeah, T visa for sure. T visa, you cannot leave the US and get a T visa. So you have to be here during the T visa process. How long does it take to get work permit with VAWA if I-485 submitted? 6 to 12 months. But once your adjustment of status application is filed, it means that you have signaled that you qualify to be here while your process is going forward. I mean an F1, F2 applicant who overstayed. Oh, okay. So the F, but it's already been a petition. Are they at risk? This is an excellent question. Unfortunately, I would say this is the category that's in danger. The F1A, F2B categories under the national. So these categories are children who are under 21, spouses of permanent residents, as well as any US sons or daughters of US citizens who are age 21 or older. If you overstayed and you have a petition pending, they cannot, you don't qualify for adjustment of status automatically unless you're applying for VAWA, right? And so if that is the case, it means that they can look at this and say, oh, you have a petition here. Oh, you're living in the United States. I see, but you overstayed and you don't have an adjustment of status pending. So let's go ahead and issue a notice to appear, and then you can deal with your petition outside of the United States. So that is the category that is in danger. Anybody who doesn't immediately qualify for an adjustment of status outside of VAWA, who overstayed or who entered the country without permission. Now, the difference here's what I want you to know as well. Let's talk about VAWA for a minute, because VAWA is very much dependent on family relationships. The whole point of VAWA, friends, is for the immigrant who is facing mistreatment to stay in the US and get relief. That's the whole point of VAWA. And so if you're in a situation where you are being mistreated and you you say you are the spouse of a permanent resident or the child of a permanent resident, you don't qualify for adjustment of status, but you're being mistreated, this is where you need to think about VAWA, because the whole point of VAWA is to allow you to stay here and get relief, get protection, get deferred action while you are here. And in some cases, you can apply for um, your own paper adjustment of status. Can you put up the contact number, please? So I'm going to say it. It's 561-405-4889. I have to figure out how to get that number back up there, but that's the number, 561-405-4889. If you go to my videos on the page, go to the link in the profile, that link tree, or link in description of the video, you will also see the number there. It's always on my video. So, and in the description of the video, give us a call. You can even schedule your own appointment. If you go to the link tree and then just confirm your own appointment, you'll be able to do that there as well. How long does it take to get the T visa receipt notice? It's about 4 months right now. Went on interview. Let's see. Went on interview for I-485 after 2-day request for evidence and cancel. Is that a good sign? It may be. Yes, we have gotten canceled interviews and then they approve all shortly after, but it just depends on what your case looks like. I'm not your attorney. I haven't reviewed your case. I wouldn't be able to know that, but it could possibly be a good sign. What do you mean when you say overstay? Overstay says if you came in on a visa and then you stayed over the time you are allowed, then that's called an overstay. My I-130 is approved and now waiting for 601. Is any chance of getting in trouble? Unfortunately, that is a possibility to get notice to appear. But here's the thing that you need to know. It's so important to know that that's not the end of the road, right? So if you have an approved petition, you have an I-601A waiver pending, and you get called to immigration court, you can go before the immigration judge. Your attorney would be able to then show that you are in the process of applying for an I-601A waiver, and they may terminate or continue your case pending, depending on the approval of the I-601A waiver. So it's not to say it's the end of the world if you get a notice to appear. It just means that you are going to have to take some extra procedural steps to convince a judge to either terminate or put your case on hold until you get an approved I-601A waiver. So I'm seeing somebody's impatient on Instagram. Keep in mind, if you've just joined, keep in mind that I go from platform to platform because I want to get to as many questions as possible. So I'm now on TikTok. Then I'm going to move to YouTube and then Instagram, YouTube and Facebook, and then Instagram. So just hang tight, put your questions in the comments, and I will get to your questions for sure. So hang tight. U.S. citizen parents sponsor adults, unmarried children, prior to date 2018. Case NVC. How long again for GC? So if they're currently processing your case, your priority date is current. If it's not current, they're not going to start processing. Once it's current and it's let me see, I think you said the category unmarried adult children, so 5 to 7 years. And maybe after that, they start processing your case another 2 to 3 years to get to the interview. What if you overstay your visa and now married to a US citizen? Can you elaborate on overstay and AOS, I think, or over visa? So in that case, you can move forward with a marriage-based green card through the adjustment of status process. But there's no room for errors with these. Now you have to make sure you're submitting a thoroughly done application, because even one mistake, they have said they can just deny without giving you any chances. Also, if you miss any documentation, so say, for example, you file your AOS, but you missed putting your medical in, or you missed putting your affidavit of support in, so they can't process your case any further, or they reject it. And then that can also trigger them to issue a notice to appear, because now you haven't properly filed your AOS, and they see it as a small space of opportunity to issue a notice to appear. So it's important more than ever to make sure, yes, you can apply, but everything has to be done carefully. Um, I'm under protection against torture, and it's over 2 years that I appeal for my case. What can I do? So if you are under the CAT protection, you should be fine right now. As long as nothing changed in your situation, you should be fine. How long to have RFE response from them? I-130. So usually they'll post that they got it, and then sometimes you won't hear anything, you'll just get the decision. So in some cases, when you submit the RFE and you will get confirmation, yes, we've received it, we're now processing your case, we don't need anything further. That probably is going to be the best news that you will get. They don't usually write you to say, hi, thanks for your I-130. Now we've really loved your response, so we're gonna, accept it. Your next answer is probably just gonna be the decision on the I-130, which could take some time. What do you mean by criminal record? Anything where you had to go through the police, you faced charges, you had a misdemeanor, you had to show up to court, would be an offense. Is my I-130 approved? Now waiting for 601. Okay, so I answered that. Is I-130, I think if can you also contact number? I'm trying to scroll through. How long does it take to get work permit with VAWA? 6 to 12 months. Does bond apply to fiance visa? No. Um, hmm. We had my green card approved on the spot. No update yet on web. It has been 1 week. Should I be concerned? Um, not necessarily. I wouldn't say it's time to panic. It might just be taking them some time to process it. I need help ASAP. I have a deportation. Get in touch with us, talk to us about it, and then we can work to help you. I filed for my husband and his children, but when they paid visa fees and when they went to the medical, I don't see the rest of it. Do you recommend places for the evaluation process? So if you're talking about evaluation for your qualifications, there are a list of places that I use. I don't publicly endorse anybody through these sites, but there are companies that I use. Can my son travel by himself with the help of an air hostess with a Jamaican passport? That is really that is too specific of a question. Yeah, generally that does happen, but is it a good idea? What about if overstayed, but you're married to a US citizen, then if you may qualify for adjustment of status and you can still move forward with that, but just do it carefully. Make sure procedurally you're not missing anything because that's where the risk comes in. Can you travel undocumented to a different state? That's very risky. Can a juvenile case that was about 13 years ago and got expunged affect my I-485? They will still need to know about it. So it's very important you do not omit it because they can see that as misrepresentation or fraud. Talk to your attorney about it, but they need to know about it to evaluate it, and it may not, just depending on the rest of your history. If it's one case that you had as a juvenile, it may fall on an exception to inadmissibility. But yes, you have to disclose it, even if it's expunged. If there is a criminal record, you must disclose it, even if it has been wiped out, dismissed, expunged. You must disclose it. Um, can I apply for asylum now? My J1 visa expires in 1 month, and 2 year rule doesn't apply to me. So you need to have a fear of returning to your country for very specific legal reasons. So if you want to apply for asylum, give us a call. Let's talk about your situation, and we can definitely tell you. Um, I came here on May 4th, 2025 on DV winner. Not received my SSN, and SSA say they said you will receive. So yeah, if you know it might not have been sent yet, you definitely have to take that up with the Social Security Administration. Overstayed AOS, marriage to a US citizen, got EAD and SSN, uploaded new unsolicited evidence approval. I wouldn't be able to say whether that will get you an approval, but if you have strong evidence of the bona fides and you don't have any other disqualifying issues, overstaying alone is not going to disqualify you here. Other issues, if you don't have any other issues that disqualifies you, then you can that could lead to an approval. Can my husband still file for me even though he's on child support? Yes, as long as he has the income requirements. Even if he doesn't meet income requirements, he can find a co-sponsor to help with that. I'm out of status. Can I fly from New York to Florida? Florida is not a safe space for people who don't have their papers. So flying, in addition to that, you're flying, it's really, really risky, a risky situation. All right, I'm gonna now hop over to YouTube and Facebook and Twitch. Hello there. It's nice to see you. Good night. How do you feel about emotional abuse from a female spouse? Absolutely qualifies you for VAWA. All kinds of abuse and mistreatment qualifies you, even extreme cruelty. Get in touch with us. That's exactly what we work on. Our phone lines are 24/7, guys. We're creating a system here to allow people to apply for their status here. We are working overtime to make sure we're helping as many people as possible. Can I fly to Maine to from Maine to NC? If you are without your papers, traveling is very risky right now. I'm trying to get a number for you because I always watch your programs. So if you go to the videos and or go to the description of the video, you'll see the number there. How long the T visa application receipts are taking to arrive? I sent mine end of May, 4 months. I would say 2 weeks to 4 months. Unfortunately, it's really backed up. Thank you so much. I appreciate that, and I feel the same way. So, hi, attorney. May God continue to bless and keep you, and keep safe. I'm praying for better days to come. Absolutely, I am too. Yeah, it's a really tough time now. How long is the T visa processing now? I would say over 18 months. Does refiling an N400 immediately after withdrawing it because of filing a little early hurt next one? Not necessarily. No, you just want to make sure that you know everything you filed in your previous one. Make sure you provide consistent, detailed information so that they don't, imply any kind of fraud or anything. How long VAWA take to be approved now? 3 years or 3.5 years. Um, but you do get your work permit while you wait. If you receive bona fide letter for T in February, when can you expect the work permit? You could expect it in another 2 to 4 months. Interested in your services. Do you have office in Springfield, Missouri? No, we are based in Florida, but we represent clients in all 50 states and the globe. No matter where you are, we can help. Applied for VAWA March 2025. No receipt notice yet. Is that okay? March, April. So 5 months, I'd say 5 months is, I've seen one of them take 5 months, one of my petitions. So it may not be out of the ordinary, but definitely see, do you have tracking? One way to get reassurance is if you go ahead and you track it. So when you send your package in, you track it and you have proof of delivery. That will tell you whether an officer signed and got it. I have a VAWA case filed since March 2025, but still haven't. Okay, I got that. God bless you. You're doing a good job. Thank you for that. I applied for VAWA and for adjustment of status at the same time. Have received prima facie and work permit. How long will it take to get a final approval for my VAWA and green card? So I would say time it about 3 years, and then after that, about 6 months to 12 months to get the green card. Attorney, hi attorney, I got the bona fide correspondence letter last November 2024. You have any idea about the EAD? So I would say about 2 to 4 months after the bona fide is issued, the EAD would come through. I already went for, and keep in mind, this is just estimates based on my own experience. I already went for my marriage-based interview. It went well, but my work authorization is not out yet. What could be the reason, please? You might get your green card before you get your employment authorization. So hopefully that's what happens. Maybe your interview happened faster than the processing time for the work permit. All right, I'm on Instagram now. Do you think it's safe to travel from one state to another? I would discourage travel as much as possible because these are points of entry that they are definitely paying attention to who's going in and out of those. Is it difficult to get sponsored by a company for an H-1 visa even after the company is willing to do it? So if we are talking about an H-1B, I think the most difficult part about it is a lottery. The fact that in the lottery, it's not guaranteed in most cases. If they have filed for your green card, then that is a different story. I'm in the process of adjustment of status through marriage. However, I move around with my marriage certificate, copy of passport and visa, copy of my U.S. citizen wife citizenship documents, and my receipt. Yeah, I definitely understand, why you would have all of that with you. Having I would say having your receipt notice is definitely a good move. And once you get your work permit, of course, that will take care of having to take so many documents. But yes, having at least proof that you have a pending adjustment of status is gonna be important here. Can I ask a question? I think you did, yes. So yeah, absolutely. Put those questions in the comment. Please, can I travel to San Francisco with work authorization card as an ID? While I-485 is pending, yes, the work authorization can be used as an identification. I believe for travel, verify with your airline though as well. I've been waiting for my VAWA receipt number since April. Called USCIS. They told me we don't have anything in your name currently. Is it still in the lockbox? How can I contact the lockbox department? So the first thing is, did you track your package? If you did, you saw um, that it was delivered, then contact the place where it was delivered. See if you could get an email to contact them, and then make sure you have proof of delivery to show it was delivered. But in regards to where you contact, it really depends on where you filed it, what kind of case you filed. I know it's Nebraska or Vermont. So that's where it's going to start. Here at SC Law Office, we do have a special attorney hotline where we email, and then we are able to ask questions there regarding VAWA applications. But in your case, you would have to do it in writing if you wanted to inquire about where your application is. Can you get a letter from Chicago office if your VAWA case is pending? It's possible. I don't know what kind of letter you're talking about, but if you're talking about a letter in related to your VAWA, if now they're looking at an interview, or they're now gonna look at processing your case at the local center, that may be the reason you've gotten a letter. I got speeding ticket a week ago. My vow has been pending since 2023. I have my work permit and prima facie. Will I be deported if I go to court? I'm worried. So you have the work permit, and that's the best case scenario that you could be in. You would not be at the top of their priority list for removal because you have the work permit. Just make sure you carry your work permit with you, and go to court. You definitely don't want to be in a situation where the court finds against you if you don't show up. But in your case, that's really a really good case scenario. You have the work permit, which means that you do have a degree of protection. Can someone still get sponsored visa through job, and how to get through it? Yes, absolutely. Those processes are still moving forward. Are jobs still doing visa sponsorship? Yes, they are still doing it. It's still a process that's in place and still moving forward. What if you work for an employer and he mistreat you? How can you adjust status in that situation? Get in touch with us. We do have to talk to you further about what kind of mistreatment you're facing. But in this case, even if you don't have your papers, there's a special type of visa that you can apply for that gives you protection, gives you a 4-year work permit, and then you can apply for your green card after 3 years, and in some cases earlier. So get in touch with us. This is exactly what we help our clients with. How long your lawyer should keep your work permit before sending it to the client. So keep in mind that I do not hold on to anybody's work permit for for longer than I have to. As soon as we get it, we send it out to our client. Because that's very important, and it really belongs to the client. It is the client's to have. So if your lawyer is holding on to, if a lawyer is holding on to your papers, holding on to your work permit, that they may be violating their own rules, professional rules of responsibility, because lawyers, I know for one in my state, lawyers cannot hold on to the record, the client's record, or their documents or official documents. That is theirs, right? So, I don't know what's happening, but you may need to lay that out for the lawyer as well to let them know that they actually may be violating rules by holding on to your work permit. I'm paroled in the country and I got married. I have my I-94. Then if you're married to a US citizen, you are able to still move forward with the marriage-based process being paroled. N3 denied and green card is about to expire. Can I-90 be filed? Yes, in some cases. Now keep in mind if it was denied because now they're claiming you're deportable, that may be a different story. But that will be the next step is you just have to keep filing your I-90. Are you guys operational in Florida? That's where we're based. We're in Delray Beach, Florida, as well as Boca Raton. What if you have a child with your American spouse? That's real good evidence of a bona fide marriage. So that can be a strong evidence. Hi, what happens if a date of birth for a child was wrongly submitted and the case is being actively reviewed? Will it cause delay? It may, because if the date of birth was wrong and the officer, uh, you know, infers that there is willful misrepresentation or fraud, then that can be a serious problem. So you want to make sure you're correcting that ASAP. Don't just sit on it. Make sure you're making moves to correct it so that they know it was a mistake and not kind of anything intentional, because that can escalate. What if you have a child with your spouse? Answer that. How many chances does one get if they fail their citizenship interview? If they fail the test, you get to come back and do another one, so you get a second chance. What about I-140? Can that trigger I-140? So here's the deal. Any petition that is filed where they find that you're removable can um, trigger a notice to appear. So yes, if you filed an I-140 and you don't have an adjustment of status pending, they can spot that you are removable based on an overstay. So it's possible that it could increase your risk. Why would people want to go to that one is N3 denied, but green card is about to expire. So I answered that. Can you be deported while waiting for your I-751 to be approved? So no, because you are given an extension, a 4-year extension, and then you're able to until your I-751 is decided. But they're still deporting my brother, and this is his situation. So he definitely needs representation, because good advocacy can definitely help. Does this also affect VAWA persons? So I think we're still talking about the policy. So VAWA allows people to stay here. And keep in mind, even going to immigration court, if you get a notice to appear, you qualify for VAWA, you can present VAWA to a judge as well. I have I-140 file in 2024. I'm waiting to file I-485. My husband is in the Caribbean. When do I file I-824 for him on the EB3? So your spouse is supposed to be included in the process. So upon approval of the I-140, what they would do is then send the file. So approval of the I-140 is when they would then send the file to the embassy for processing there. And if you did indicate that your spouse is in the US, then you would definitely need to do an I-824 in order for his case to be processed at the embassy. Is it dangerous to apply for citizenship it may be if you are faced with certain risk, like if you do have a criminal offense in your background, that can present a risk. Um, All right. All right. That's going to be it for me, guys. I am working to get back tomorrow again. So please like, subscribe, follow, hit the notification bell, comment. This is how other people will see this information that can empower them through the immigration process. And so we have that responsibility now to do that. But also, to if when I come on, because I come on all different times of the day, so when I come on you can get notification that I'm on, and you can go ahead and jump on and ask your questions. I see one more. I see a follow question, and I cannot resist answering a follow question. I applied for FAWA in January 24th, 2023, but I recently got a pretrial diversion. Is gonna get dismissed once I complete my year. Would this affect my case? So it may, if you file for FAWA in 2023, there is going to be some time. You may have time on your side because it takes about 3 years for them to decide the VAWA. And so if you, let's see, so 2026, it's going to take a year. So you could get that letter just in time for a possible request for evidence based on that offense. And you can always, no, I'm not your attorney, and this is really strategic, but even notify them. That may be an option, to notify them that your case is about to be dismissed. um, so just to explain this to them, but time may still be on your side. All right, that's going to be it for me. Thank you again, everybody, for your time tonight. I appreciate it. I am going to work to get back tomorrow. I believe I am so excited because I was able to do Monday, Tuesday, Wednesday, Thursday. And so let's complete end the week with a bang with me coming tomorrow again. So look out for me, follow, like, subscribe, share, hit the notification bell so others can see this and so that you can see me when I come back on tomorrow. Have a good night, everybody. And let's walk with faith. Let's be solution oriented and just know that we are here. We're here for our clients. That's one of the values that we have. We are there all the way with our clients. So you can give us a call and we can talk in a confidential process and see if you qualify and move forward very quickly. Have a good one. Bye bye.